Please stand by. Good day and welcome to the Billing Sundberg's Homebuilder webinar, Recent Developments Affecting Consumer Class Actions. Today's call is being recorded. At this time, I'd like to turn the call over to Mr. Phil Stein. Please go ahead, sir.
Thank you. We're actually calling this Defending Against Class Actions and Handling Consumer Protection Issues. We're going to focus on some new developments and winning strategies pertinent to those areas. Let me mention just a couple things up front. First of all, this is the first in what we plan to conduct as a monthly series of webinars geared principally to homebuilder clients and other homebuilder companies throughout the country, but also to other major companies that deal with a lot of the same issues in their day-to-day business affairs. The second thing I wanted to mention is that if you look at the bottom of the first screen, you'll see Bilzen.com and Homebuilderlegal.com. Let me just ask you at some point after our webinar today to take a look at both of those. Bilzen.com will give you a little more in-depth feel for our practice and some of the issues that we typically handle. Homebuilder Legal, as the name suggests, is focused on a lot of issues of importance to the homebuilder industry, both on the legal side and, for that matter, on the business side, and we think those will be good resources for you. I guess the other thing I should mention is that this is, as I said, a monthly series, and the second installment has already been set for June 26th. There will be a discussion by one of my partners, Stephen Lear, with respect to joint ventures. Let's get started. The area of class action developments, or the area of class actions in the last several years, has been one that has been filled really with some very positive developments for defendants, for the major companies that are most often the targets of class actions, the entities that plaintiffs' lawyers tend to want to go after. The developments really cut across two big areas, both, as I said, in a very positive way for those companies. The first is that courts have cut back sharply on the ability of plaintiffs to even bring class action lawsuits at all. The second is on those more limited occasions now in which plaintiffs are able to bring a class action, courts are also, in their decisions in the last few years, making it more difficult to maintain class actions. And so both of those developments are resulting in increasing difficulties for plaintiffs and increasing successes for defendants who would otherwise be the targets of class actions. One of the ways, or one of the reasons, that class actions have really diminished and become, thankfully, less of a threat for the defendants who tend to be targets of them is that there have been a series of Supreme Court decisions, three in particular in the last several years, and a fourth that I'll get into as well. But in each of those, the Supreme Court talked about the rights that parties have to bring class actions, and have talked about, in particular, whether on the front end of a consumer contract or a contract with another party, a corporation can kind of rule out of bounds prospectively whether a plaintiff has the ability to try to maintain a class action. In each instance, the Supreme Court has come to a decision that was favorable to the defendants. For example, in 2010, the Supreme Court held in a case called Stolt-Nielsen that even when an arbitration agreement is silent as to whether class-wide arbitration proceedings are permitted, you shouldn't assume that the defendant therefore meant that it was okay for a plaintiff to try to maintain a class action. In other words, you don't even have to have specifically said in your consumer contract or employment contract that you, the plaintiff, or you, the employee, you, the consumer, are forbidden from bringing a class action. It's almost the other way around. You have to have specifically said, the Supreme Court implied, that class actions were something that could be maintained. What I just said might be going a little bit too far, but not too far from what the Supreme Court seemed to be suggesting. Again, silence doesn't mean that you should assume or infer that a class action can be maintained. In the next year, 2011, in a very close vote, 5-4, the Supreme Court held in a case called Concepcion that the FAA, which is the Federal Arbitration Act, preempted and superseded the application of a California law that had been used by a lot of plaintiffs' attorneys to get around class action waivers. There's a doctrine in California known as the unconscionability doctrine that had been used by plaintiffs and their attorneys to say that class action waivers were unconscionable. Well, here the Supreme Court in this Concepcion case said that the Federal Arbitration Act effectively trumped that, such that an arbitration agreement containing such a waiver should have been enforced by the lower court, and the parties were required to go to arbitration. And there, of course, would not be a class action in that arbitration. In a third decision in 2013, the Supreme Court held in the case called American Express versus Italian Colors that an exception to the Federal Arbitration Act that was known as the effective vindication exception only protected a plaintiff's right to pursue a statutory remedy, but not pursue it as a class action. In other words, what the Supreme Court decided in this third of these three recent cases was that that effective vindication exception did not prevent enforcement of a consumer contract waiving class action proceedings. And that was true, the Supreme Court said, even when the cost of individually arbitrating a suit grossly exceeded the maximum individual recovery. You hear that a lot, or certainly heard that a lot in the past. Your Honor, we have to be able to maintain a class action because the costs of pursuing on an individual basis, either in arbitration or in court, pursuing this claim would so far exceed what we are expecting to recover, it just wouldn't be fair. Well, the Supreme Court essentially said tough luck on that one, and here again paved the way to companies being able to rule out of bounds a lot of class action rights. Now, after those three decisions, kind of the upshot is that defendants really can't be compelled to submit to class arbitration proceedings without some affirmative evidence of their intention to do so. The other big effect of this is that contracts waiving class actions, whether in a judicial case, actual litigation, or an arbitration, are now much more likely to be enforced than they were, say, 5 years ago. I mentioned earlier that all kind of goes to the issue of whether a class action can even be attempted or pursued at all. But there are other recent class action trends that, as I also mentioned, really also have the effect of making it harder, even if you theoretically have the right to pursue a class action, to really get any traction with it, keep it going, and be successful with it on the plaintiff side, which of course is all very good news for defendants. Along these lines, many courts now require that plaintiffs actually have to prove substantial portions of their cases on the merits at the class certification stage. Just to elaborate on that, you in the past had a situation in which a lot of judges would look at a class certification proceeding or the class certification stage of a case almost like the way they would look at a motion to dismiss, meaning we're not really going to get into the merits of the dispute. We're really just looking at some kind of narrow procedural issues. Well, after a series of cases in the federal courts in recent years, that really isn't the case anymore. And now you have courts saying it's not like a motion to dismiss. A class certification, in fact, is maybe one of the last good opportunities we're going to have to make some decisions that really bear on the issue of whether this should be pursued as a class. In other words, courts are much more likely now to look at a bunch of substantive issues early on, which typically favors the defendants. If a good defense counsel can point out some things on the merits of the case that are going to make this case very difficult to maintain, make it very difficult for the plaintiffs ever to succeed, you've got a much better shot at denying class certification on the basis of those merits issues. Specifically, for example, what the Supreme Court said in another very noteworthy case lately of recent vintage called Walmart versus Dukes, the court said that lower federal courts, are allowed to, quote, probe behind the pleadings, unquote, and review the merits of the case during the certification process because, the Supreme Court said, courts must conduct a, quote, rigorous analysis, unquote, which will frequently entail some overlap with the merits. And that was a case in which the stakes really couldn't have been higher for Walmart. The case involved a class action lawsuit against that company for gender discrimination with regards to pay and promotion matters. The class had been certified by the district court and then affirmed as a class action by the Ninth Circuit Court of Appeals, and the class was going to consist of about 1.5 million plaintiffs who were current and former employees of Walmart. So when the Supreme Court said, we're going to dig into the merits, we're going to take a harder look at whether this group really should be treated as a class, that was in and of itself a major victory for Walmart and for other corporations that tend to be the targets of class action proceedings. Other class action trends that, again, are pointing in the direction of the defendants in terms of being favorable for them. Several of the standard time-honored class certification requirements that go to how you define the class or terms that are in the class action rules like numerosity, commonality, and adequacy of representation, all of those, along with other subparts of the rule that I mentioned here on this slide, are now, as a result of numerous court decisions, considerably more difficult for plaintiffs to establish. All of this, again, has the effect of making it much more perilous, much more difficult for plaintiffs to even think about bringing a class action. They're going to invest a lot of money, the lawyers, in fighting a lot of battles that it's increasingly difficult for them to win. Yet another trend of late, a number of courts have essentially nullified what used to be called issues classes under Rule 23c4. Again, this kind of goes to what I was talking about earlier, the issue of having a more substantive, rigorous, merits-based analysis earlier on in the proceedings. They're requiring courts to examine whether the case as a whole satisfies what's called the predominance requirement of Rule 23b3. Now let's talk a little bit more about the Walmart versus Dukes case because it gives you a little more detail about the kinds of arguments, the kinds of buzzwords that tend to be successful for defendants when they're encountering these kinds of claims. The Supreme Court was again, the court that was adjudicating Walmart versus Dukes after a class had been certified by the lower courts. And the Supreme Court held that commonality under Rule 23a2 requires the plaintiffs to prove they've suffered the same injury, not similar injuries, but the same injury, and that their claims must depend on a common contention that essentially is going to be so capable of being resolved on a class-wide basis that in one stroke, essentially, as the court said, we can decide whether this issue pertains to the class or not. It doesn't mean it's going to be an easy case from that point forward. Obviously, there's going to be a lot of litigation and discovery about those threshold issues, but the court is saying we need to be in a position where once you've done all that legwork for us and briefed the issues, we can decide everything as to everybody in, as the court put it, one stroke. The court also held that use of statistical evidence to demonstrate a disparity in pay and promotions among men and women at Walmart was not enough to establish a common question or a common contention among all class members. Now, that's a really big deal, as may be apparent to you. If it's not, let me just say briefly, it's a really big deal because when you've got, on the plaintiff side, thousands or in this Walmart case, millions of supposed class members, what you clearly want to do on the plaintiff side is not have to go person by person, case by case, and prove up what the problems are. While there may still be some means of short-circuiting things so that you don't literally have to go through every person in a 1 million or 1.5 million person class, the court was signaling it's going to be much more difficult because you can't just give us some statistical sampling that isn't really rigorously conducted. We need to know more than that, not just get a statistical sample, before we can determine whether there's a common question or a common contention that is sufficient to allow us, the court, to confer class status on this case, on the group of plaintiffs in this case. Now, having told you about all those good trends that are clearly pointing in favor of defendants with regard to class actions, I don't mean to suggest that class actions are dead or even really dying. Definitely some class action issues persist. And some types of cases, more than others, are finding their way through these new landmines and, remaining viable. Some of the types of class actions that do at least generally remain viable or at least are more likely to remain viable going forward are certain types of securities fraud cases, wage and hour actions, and antitrust class actions. My guess being that it's just a little more of a time-honored tradition, so to speak, in the views of courts for securities fraud matters or antitrust matters to at least be strongly considered for class action treatment. I guess a lot of judges, when they think of class actions, think first of securities fraud and maybe wage and hour and antitrust class actions, and so they're a little more lenient, relatively speaking, with respect to whether those types of actions can be maintained as class actions. But the overall impact of the case law trends has been to curtail substantially the ability of plaintiffs to obtain class action treatment. In the area of shareholder class suits, some interesting changes of very recent vintage. I mean, I'm talking even in the last couple weeks. The Delaware Supreme Court just upheld within the last few weeks a corporate bylaw that requires the losing party in litigation against the company to pay the winner's legal fees. So, you've historically had a situation in which shareholder suits, whether shareholder derivative suits or other kinds of shareholder classes, are settled quickly, and companies agree to give shareholders more information about a deal, for example, but no more money. That may have been something companies were willing to do in the past, but the companies had typically paid plaintiffs' attorneys' fees, and in cases of this type, those fees averaged about $500,000. So there was at least some stake, some incentive for plaintiffs to latch onto, and plaintiffs' attorneys, I guess more importantly, to latch onto in either threatening a shareholder class action or actually filing a shareholder class action. They thought, well, worst case scenario, we'll probably get a relatively quick settlement and we'll at least get our attorney's fees paid. Now, as I said, the Delaware Supreme Court is saying, at least in Delaware, because this does only apply to Delaware, but obviously so many corporations have Delaware corporate bylaws, we're going to require the losing party in a lawsuit to pay the winner's fee. So there's a lot of skin in the game, a lot more skin in the game at least, for plaintiffs' attorneys if they want to mess around with these kinds of suits. If widely adopted, fee-shifting bylaws would, of course, raise the risk associated with filing these lawsuits. As I said in the slide, it's kind of an obvious gut check for plaintiffs' attorneys. Do we really want to pursue this, knowing that if we lose, if our theory wasn't quite correct, if our facts weren't quite correct, we may have to foot the bill for this action? Of course, some class actions are going to proceed to either to the merits or more likely to a stage at which a defendant feels like it does need to resolve it and, quote unquote, have to purchase peace under the circumstances of the particular case. Even in this area, I guess the point here would be defendants are making some real inroads and are getting some real support from the judiciary in terms of purchasing complete peace as opposed to some sort of piecemeal settlements that were the unhappy results for some defendants in the recent past. Class action settlements now tend to have a preclusive effect that really do allow the defendant to purchase complete peace through a settlement and avoid future liability. A broad construction of a class can and often does lead to the inclusion of would-be litigants whose claims are somewhat different from the rest of the class. That used to give rise to the ability of those plaintiffs, either on an opt-out basis or just by saying, I'm not even opting out, I wasn't part of the class because my claims were somewhat different. Now, if you've got a broad construction of a class, it's much more likely that you, the defendant, can say those so-called stray individuals are now precluded from asserting any individual claims. And really, the broader the scope of the class, as a result of that, the more would-be litigants are finding themselves precluded from asserting individual claims. That's kind of the upshot with respect to major class action developments of late. But there are other issues that we wanted to touch on, really from a consumer protection standpoint. And I'd say that the hottest consumer protection issues right now that are out there among so many different varieties of consumer protection issues that we couldn't possibly touch on today. Two hot issues are standing and fair lending / CFPB issues. That second one, fair lending and CFPB, which is Consumer Financial Protection Bureau issues, I'm really using kind of as an example or as a stand-in for all sorts of other areas or issues that seem to be on the radar screen of this relatively new animal out there, the Consumer Financial Protection Bureau. I think you're going to find, just kind of previewing what I'm going to be getting into, if you're not already aware of this, the Consumer Financial Protection Bureau, whether you think it was a good idea, a bad idea, or whether you're indifferent to it, it sure is kind of flexing its muscles and showing itself to be a really activist, not only watchdog, but activist agency that is not shy about pursuing enforcement actions, threatening enforcement actions, and taking a broad purview or carving out for itself a broad purview over a wide array of regulatory issues. Let's talk first, though, about standing issues. And just to give you a little bit of background, the Federal Trade Commission back in the 1960s encouraged the states to enact their own consumer protection laws, which came to be known as Little FTC Acts. The reason I'm telling you this is because you need to be aware, if you aren't already, that almost wherever you're doing business or wherever you're dealing with end customers, there is some real possibility of being subject to attack under a particular state's consumer protection laws, in addition to various consumer protection tools that the federal government likes to wield from time to time. Talking first about these little FTC acts, that is the state acts, the general purpose, the general background to them was that they addressed several policy concerns. Buyer beware, or caveat emptor, was thought not to be a fair doctrine because of the imbalance of power between the seller and the buyer, and it was thought that defrauded consumers were not able to achieve vindication because, kind of like we were talking about with class actions earlier, the amount of money at stake was too small to warrant litigation. Well, as with many things in life, I guess what may have been an originally necessary idea or even an originally good idea has kind of turned into something beyond what everybody may have comprehended long ago, to the point where it's now very uncertain from state to state not only what laws you're subject to and what you might be, what laws you might be challenged under, but it's also very difficult on a state-by-state basis to kind of keep your finger on the pulse of who it is who might have the right to bring a claim against me. And it's not something you would look at, I guess, as kind of an academic exercise, but when someone is making a complaint about you or threatening you with a claim or actually filing a claim against you, my point here is that the first thing you need to do, perhaps in this type of case more than any other, is think long and hard about whether this particular plaintiff or would-be plaintiff is the kind of person who has the right to bring this kind of claim. As an attorney who primarily handles things on the defense side, look, I always take a look at whether a plaintiff has so-called standing to pursue a claim, whether we're being sued by the right party and whether that party has a right to bring the claim. But what I'm emphasizing here is that on these consumer protection issues, because there's such a wide assortment of rights or lack of rights across the states, you really have to focus hard on whether the party has standing. Just to give you some examples of the great varieties from one state to the next, you have some states that some of which you might not have expected would be tough on these issues or not tough on these issues, but some states who don't place any restrictions at all really on who can be a plaintiff under their little FTC acts. Under Connecticut's consumer protection law, for example, really any person or business that suffers a loss, an identifiable loss, can file a lawsuit for damages. So the point is you don't necessarily have to have been the entity that sold a product or provided a service to this person. If somehow, obviously there's still going to be causation issues that would need to be proven against you, but at least in theory, anybody who suffered a loss as a consequence of something that you sold or some service that you performed could file a lawsuit for damages, and it wouldn't necessarily quickly be kicked out of court for lack of standing. Really, any act also within the general description of consumer activity, kind of broadly conceived, applies. So there's very broad standing in Connecticut. Arizona is a state you might not automatically think of as one that would be very liberal in this regard, but it actually is. In Arizona, the Consumer Fraud Act allows any claim against any person who has acquired any monies or property, real or personal, by means of any practice declared to be unlawful by the provisions of this article. as you can imagine, plaintiffs and plaintiffs' attorneys can have a field day with that kind of very broad language and can drum up, if not a class action, at least a lot of different individual claims, or perhaps even some sort of mass action or group action based on injuries, because the definitions of injury and the definitions of who can bring a claim are so broad. Now, by contrast, you've got other states that do impose substantial restrictions on standing. Again, maybe they wouldn't be the ones you would automatically think of as ones that would be really tough on consumers. In Colorado, I won't bore you with the entire 5-element test, but it is here on the slides, and it's a fairly difficult 5-element test for plaintiffs to meet. It's hard to satisfy all those requirements. Likewise, Alabama, a plaintiff must be a natural person who buys goods or services specifically for personal, family, or household use, and who does suffer monetary damage. That might not sound like it's that tough a set of requirements, but it's actually a lot more nailed down and a lot narrower than a lot of other states. Let's talk about an example of consumer protection enforcement action that I know is of interest to members of the home builder industry in the audience. On May 17, 2013, the CFPB issued a consent order to a builder in Texas, Paul Taylor Homes Limited, as well as the corporate affiliate and Paul Taylor as an individual. It did so based on the CFPB's findings that Taylor entered into a sham joint venture arrangement with a bank that resulted in Taylor receiving compensation for referrals in violation of Section 8 of RESPA. Now, the CFPB was arguably being pretty vigilant, pretty activist as a watchdog in this area. What it found, though, is that there was a joint venture between the Paul Taylor Homes entity and this bank called Benchmark Bank. And it was an arrangement much like a lot of large home builders have. A lot of large home builders, of course, have affiliated mortgage companies, captive mortgage companies. Paul Taylor Homes didn't, but it was trying to get the next best thing, which was a joint venture with this bank with which it had some sort of relationship. However, I guess there wasn't a whole lot of attention, at least in the CFPB's mind, paid to how to structure the joint venture and how the joint venture would actually operate. The joint venture, according to the CFPB at least, according to its findings, had no employees. All work was being done on behalf of the joint venture by an employee of the bank. It didn't have its own office space, it didn't advertise to the public, and it conducted no origination business outside of the referrals that it received from Taylor. Let me pause there. Of some concern to a lot of companies that I work with and that others at this firm work with that do have their own mortgage companies, you look at a couple of the items that I just read off, at least, not advertising to the public and conducting little or no origination business outside of the referrals that it receives from the home builder parent, that could apply to a lot of home builder affiliated mortgage companies. And it's probably not a coincidence that there's been a renewed focus, kind of a spike in interest on the part of a lot of independent mortgage companies not affiliated with home builders in resurrecting kind of a long-standing practice of questioning and challenging whether it's fair to have a mortgage company affiliated with a home builder, especially when the home builder, can and sometimes does offer certain types of incentives for a customer to work through the mortgage company in getting the home builder's financing lined up. So, understand that this particular action by the CFPB against Paul Taylor is of interest. One of the reasons I'm bringing it up is because at least potentially it's something that plaintiffs or an agency such as the CFPB can latch onto as a means for scrutinizing relationships between home builders and their mortgage companies. On the flip side, I think it's the case. I think it's historically been the case, albeit not with the CFPB because the CFPB is kind of new on the scene. But historically, it's been the case, I think, that when there's been any kind of question, any kind of even minimal scrutiny of affiliations between home builders and in-house mortgage companies, there's a pretty compelling case to be made, and it's been recognized as a compelling case by those other agencies that there are some real efficiencies and benefits to consumers as a consequence of those linkages. In any event, back to the Paul Taylor case, again, the CFPB found that there were a lot of indicators that this wasn't a true joint venture, at least in the CFPB's mind. All 32 loans that had been originated by the joint venture between the date of when it was formed and the date of the consent order were funded by the bank, not really by anyone specifically associated with Paul Taylor Homes. So there are lessons to be learned from this, and one of them is that a joint venture, really no matter how small, does need to be something that you can show is a real functioning business, and you want it to be able to pass as many items on a 10-factor test that's set forth in a HUD RESPA statement of policy as possible. You can look up that statement of policy just to see what those 10 factors are. But you want to be able to establish, in other words, that it's a bona fide settlement service provider, not a sham arrangement. Some of the problems here that go to some of the factors on that 10-factor test were, again, no employees, no really clear, identifiable, distinct operations, no office space, and not really competing in the market. Now, let's talk about fair lending, which, as I said, I'm using kind of as an example of a larger group of issues that the CFPB, the Consumer Financial Protection Bureau, and some other regulators seem to be really interested in, seem to be really focusing on. Regulators, or in theory private plaintiffs, let me come back to the or in theory part in a second, but regulators can bring fair lending enforcement actions and often do bring fair lending enforcement actions or litigation based on three different legal theories of lending discrimination, and they're detailed here. Overt discrimination, I think everybody kind of understands. There's just open, identifiable discrimination, at least allegedly. Disparate treatment is, you've got some sort of policy that arguably is discriminatory and arguably has resulted in some sort of discriminatory treatment. Disparate impact is what we're going to focus on in a couple of minutes, because that's potentially the really scary one, because the whole premise of disparate impact is a regulator or again, in theory, a private plaintiff is saying, I concede, I agree with you. There's nothing wrong with your policy. It's a totally neutral policy. You haven't done anything where you were intending to be discriminatory, but you are somehow arriving at results that seem to favor one group over another group, or one set of groups over another set of groups. So even though we think your policies are fine and deserve our congratulations for having been structured in a way that's totally non-discriminatory, we're still going to come after you because we think either as an entire company or in some segment of your operations, like some local branches or some division of your company, you seem to be having results that create this or reflect this kind of disparate impact. I'm going to come back to that because that's such an important issue, but I did want to circle back for just a second to the or in theory private plaintiffs part of this slide. The good news here is that it really is at this point only in theory that private plaintiffs could go after your company or a company you care about for this on this kind of theory. That Walmart versus Dukes case that I mentioned earlier, in some ways, along with a couple other legal developments, seems to have really, really undercut the ability of private plaintiffs to bring a fair lending enforcement action. Even though Walmart versus Dukes, as I said, really pertained to gender pay discrimination, there were certain comments, certain statements by the court there and in other recent cases that really, really seemed to undercut the ability of private plaintiffs to bring this kind of action. We still have to worry about regulators on these issues, and so I do want to focus again on disparate treatment and disparate impact. Just to kind of nail down the difference between these two theories, disparate treatment is circumstantial evidence that the lender intentionally treated similarly, it should say, situated persons differently on a prohibited basis. So even if you weren't motivated by prejudice or a conscious intent to discriminate, differences can be considered intentional if you really can't point to a credible non-discriminatory reason to explain your policy or practice. Now, what that suggests, of course, is that the people, either you or the people you're working with, really need to pay more attention than ever when you've got very vigilant watchdog groups out there, pay more attention than ever to documenting, why some discretion was taken, why some discretion was exercised in a particular way. And I'm sure generally you can come up with credible non-discriminatory reasons for why a loan was turned down or why the loan terms weren't quite as favorable for one prospective borrower as for another. But you need to do that. Now, disparate treatment, because it's circumstantial evidence and because it doesn't have to be motivated by prejudice or conscious intent to discriminate, that is potentially kind of scary enough for defendants to think about as something they could be targeted for. But disparate impact is the really big one. Because, again, that's something where the evidence is everyone agrees the lender applied a neutral policy or practice uniformly to all credit applicants, but the policy or practice has a disproportionately adverse impact on members of a protected class group without a proper business justification. And just to emphasize the fact that, again, I'm using fair lending as an example, understand that I am aware of companies, and there have been reports of companies, not in the lending context, but in other areas, other product areas and service areas that have, at least on an occasional basis, been targeted, been scrutinized by the Consumer Financial Protection Bureau, among other agencies, for having supposedly not been fair with a consumer in a particular transaction. I have heard of home builders at least receiving letters of inquiry from the CFPB, for example, about whether their overall financial dealings with a consumer were fair or not. So this is something that potentially is a real bludgeon for the CFPB to use, and potentially a real opportunity for it, if it's inclined to be activist, which it is, to pursue all sorts of actions that catch its fancy. There's something called UDAP that is a little different from the traditional fair lending laws, but also something that really warrants your attention and your company's attention. UDAP stands for unfair, deceptive, or abusive acts or practices. They're prohibited by the big, voluminous Dodd-Frank legislation from a few years ago. And it's not limited to expressly regulated industries, nor is it limited to the largest companies. You can be targeted for unfair, deceptive, or abusive acts or practices of a variety of types. And the CFPB, though it hasn't been open about everything that it's doing, has been very open in saying compliance with this set of laws, the UDAP laws, is a key concern of the CFPB. And I've underlined in the last bullet point on this slide what is something that is of real concern to a lot of clients, a lot of companies. The CFPB has also said, look, we're going to be the agency that really interprets UDAP. Now, that only works so far. The defense lawyer in me will tell you that they can say that they're going to be the ones who interpret what UDAP is all about, but ultimately, if they really want to pursue this, the courts are going to have to weigh in on whether the CFPB's interpretation is in compliance with these laws that have been on the books a lot longer than the CFPB has been in existence. But I think we all understand that sometimes courts will defer to federal agencies and say, well, it's part of their charter that they're going to look into this. They've asserted regulatory authority over this, and I'm going to pay them a lot of deference. So it is of great concern that CFPB says it's going to interpret UDAP. UDAP is arguably the most powerful tool, along with disparate impact, in the CFPB's arsenal, because almost any practice can be attacked under some broad standards that are being applied by the CFPB. The traditional fair lending laws are a powerful alternative, including the disparate impact case law that's developed under the fair lending laws. Now, I do want to talk a little bit later about the fact that it's not like I'm saying you can't prepare yourself, you can't defend against these kinds of claims, and you can't be proactive in trying to limit the likelihood, reduce the likelihood that someone is going to scrutinize your company for unfair, deceptive, or abusive acts and practices. You can, and I want to talk to you about some risk management issues a little later, and some things that we can learn from consent decrees and enforcement actions that will aid you in compliance. But before we get there, let me just, I don't want to be a broken record about this, but there's so much vagueness associated with UDAP that it is difficult, and it's going to require a lot of attention to kind of gear up for reducing that likelihood that you're going to have to deal with these kinds of issues. There's a long quote here I won't bore you with from the director of the CFPB, Richard Cordray, from about a year ago, where he just off the top of his head lays out several broad categories of ways that he thinks consumers are often injured. And what this suggests to me and a lot of other people who read his testimony and read his quote is that they really do see so many different opportunities. I mean, they're focused on credit cards and home loans and non-lending activity. Anything really with a consumer finance angle to it is something that they see as potentially under their watch and potentially under their authority. Breaking down, some of the prongs of this unfair, deceptive, or abusive acts and practices legislation and case law, let's talk a little bit about unfairness. Another reason to really pay this some attention and to engage counsel, perhaps to help you gear up for prevention, help you manage your risk in this area. You got to understand that the CFPB has made clear that in its view, when they're looking at whether a monetary financial injury has been suffered, consider that an act or practice that causes even a small amount of harm but causes it to a large number of people is considered by the CFPB to have caused, quote, a substantial injury, unquote. And that means they're motivated to act. So you hurt a lot of people a tiny bit, and in the CFPB's view, that's something that gets their sirens going. Actual injury is not required. Just a significant risk of concrete harm is sufficient, according to the CFPB. So you haven't hurt anybody yet. We grant you that. But we see that you're doing things that pose a significant risk of concrete harm in the future, and so therefore we want to talk to you about how we're going to regulate you. Some of that bleeds into abusive practices, but I have to tell you that there's not a whole lot out there that defines what an abusive practice is. And borrowing, I guess, a quote that a Supreme Court justice used back in the 1960s in dealing with a pornography case, the Supreme Court justice said, well, I don't know how to define it, but I'll know it when I see it. Well, that's what Director Richard Cordray said about abusive practices. He's in charge of this organization. He says, I can't really tell you what an abusive practice is, but I'll know it when I see it. So I'm sure that doesn't give you a whole lot of comfort. Consumer complaints. A lot of people ask, and justifiably so, what impact does a consumer complaint have in triggering serious scrutiny, serious inquiries by whether it's the CFPB or some other regulatory agency? How much is a consumer complaint going to have an impact? And the CFPB has said, look, consumer complaints play a big role in our detection of unfair, deceptive, or abusive practices. And that's not to say that they think every consumer complaint has merit. I'm certainly aware of a lot of instances in which they recognized that a consumer complaint had no merit. But I think the CFPB has made clear that it believes that consumer complaints may well show some sort of weakness in an institution's compliance management system, and so the CFPB kind of seems to file it away for further study or possible further review in the future, believing that, yeah, maybe this particular consumer was kind of blowing smoke and didn't have a terrible problem, but there may be something here that we need to look at in terms of this institution's training, internal controls, or monitoring. And so, for that reason, even more than other reasons that might already be considered at your company, I think it's very important for companies to track the categories of complaints that are being reported, either by the CFPB in terms of the CFPB saying, hey, we got this complaint, or I guess my slide should also say reported to the CFPB. If you have the ability, and you do, frankly, to see what is publicly being reported to the CFPB, and there are some some websites and media sites you can take a look at that give you some of that information. Take a look at what kinds of complaints seem to be getting reported. Keep track of that and try to do an assessment of what your policies and procedures are with respect to the kinds of issues that seem to be giving rise to these complaints. So let's talk about fair lending risk management. And there's a lot of detail on these slides, so I'm just going to give you some highlights in the interest of time. But the CFPB has communicated some of its expectations with regard to what kind of management systems your company should have in place to demonstrate that you are paying attention to various consumer protection kind of issues, whether it's fair lending, whether it's something else that's more integral to your business than the lending process. But what are you doing to make sure that consumers are being treated in a fair manner, in a way that will satisfy the CFPB and its activist expectations? One of the keys seems to be board and management oversight. That there is real involvement on the part of the board and senior members of management in creating, implementing, and reviewing the policies and procedures that are in place. And I also want to highlight from this slide, compliance programs and a compliance audit, and particularly compliance audits. I guess everybody has or has given, I hope at least, serious attention to the idea of having a solid written compliance program in place for various procedures that deal with how you interact with consumers or the general public. But you got to go a step beyond that. I mean, have those written policy procedures, have training, have monitoring and corrective action for instances of lack of compliance, and document all these things. And then that last little check mark on this slide, compliance audits, very important to make sure that no matter how good your chief compliance officer or chief risk manager is, it's very important to have someone who's independent of the compliance and business functions, periodically taking a look at how you're doing in your most important, consumer interface processes, whether it's fair lending if you're involved in lending, or any other kind of consumer interface activity that your business is engaged in. Have somebody, whether it's outside counsel or someone else you trust, come in and take a look at, as a periodic audit measure, how are we doing, and have that person directly report to the board of directors or some board committee with respect to what they uncover, so that you don't give your compliance people, no matter how good they may be, don't put them in a position where they feel like they're going to be in trouble if they go to the board or a board committee and say, I got to tell you, our compliance has been terrible, or our we've got a lack of sound policies and procedures in place. Maybe a new compliance person is comfortable saying that, but someone who's been on the job for several years probably is a good bit less likely to want to volunteer that kind of information, hence the need for independence. Now, we know that when the CFPB does an examination under the unfair, deceptive, abusive acts and practices, series of laws that I talked about, we know that there are several things that they seem to be most interested in seeing, and they want to make sure that you have them, of course. And those are listed on this page. Training materials, procedure manuals, and disclosures are things that are important. But that fourth bullet point, the next to last one on the page, minutes of board and committee meetings, particularly those relating to compliance. It's a great idea to make sure that in some of your board and or committee meeting minutes, you've got to be keeping those minutes first of all, but in those minutes, from time to time, let's have at least some section devoted to the fact that hey, we as a board or we as a board committee talked about compliance issues, we got a report from this person, we reviewed certain materials. I mean, that's something that the CFPB seems to regard as evidence of at least sound attention to these issues, or maybe some CFPB people would say that's the bare minimum, but either way, whether it's evidence of soundness or whether it's the bare minimum, you do need to be doing it. I mentioned earlier that there are some things that we can learn from consent orders or from actions that the CFPB has taken so far, from lawsuits that it's filed, because it has filed a number. What seem to be the common themes or the tipping points that lead to allegations of discriminatory pricing or other unfair or abusive kinds of acts or practices. One of them is that really scary one. Broad discretion allegedly resulted in a disparate impact. Not that your policies were wrong, but there was a lot of discretion being exercised by your loan officers or other people interfacing with consumers, and they exercise their discretion in such a way that the CFPB comes in and says, hey, it seems like older people or men are being favored over younger people or women. These are all things that are of obvious importance to the CFPB. It wants to monitor them, and so broad discretion is something that I'm going to suggest to you. Number one, you might want to curtail a little bit. You don't want to take away people's ability to think and to exercise discretion, but maybe let's rein it in a little bit, and in particular, document exercises of discretion. A lot of loan officers will document, for example, traditionally when they're making an exception to an investor's policies, and they'll make sure they've got approval from an investor if necessary. But what isn't as often documented but really needs to be under this new regulatory regime are exercises of discretion that are not really exceptions to an investor's policies or to your own company's policies, but just, hey, I'm going to use my discretion, I'm going to use my professional judgment, and I'm going to come out in this direction with this borrower and in a slightly different direction with this other borrower. Doesn't mean, we don't have to be robots. You can't run your business that way. But it is a very good idea to at least take the time to have your people document why they decided to exercise their discretion in this favor, even if it doesn't constitute an exception. Some of the other tipping points that seem to spur allegations, well, one of them I just mentioned, little or no documentation of the business rationale, financial incentives for loan originators in the lending context to charge higher rates or fees or to steer borrowers to higher cost products. So that the memory of everything that preceded the financial crisis is, of course, very, very much fresh in the minds of the CFPB. Along the same lines, settlement orders do teach us a lot, and I'm happy to discuss settlement orders, on an individual basis with you, not in this webinar, but some general themes that we can discern and that we can learn from are that potential liability, at least according to the CFPB and other watchdog groups, can extend several years into the past. There have been some recent cases within the last year or two in which the liability that was alleged related to things that were done back in 2004. So many years back, arguably beyond the statute of limitations, but the CFPB is at least trying its hand at assessing liability for things that go that far back. I kind of touched on this next point earlier, but investigations can be spawned or sparked from a statistical disparity just in a single geographical area. So you could be a national or international business, and at least in theory, the CFPB could say, on the whole, it looks like you're doing a great job, but gee, that division of yours in Michigan, or even just in Grand Rapids, Michigan, is of real concern to us, and we want to focus on that, and we're going to do an investigation. Another thing that really requires your vigilance and your employees' vigilance. Lenders face potential liability, and not just lenders, companies face potential liability for the actions of third parties. So in the lending context, you as a company can face potential liability to the CFPB or HUD or the FHFA for the actions of third parties like mortgage brokers. Now, again, turning to fair lending risk management, using that as our example, just to kind of sum up, the terms of regulatory settlements do tend to reflect and even become regulatory expectations. So we look at these settlements, those of us as attorneys studying these things, look at them and are able to counsel our clients and say, here's what the CFPB seems to be expecting. And so let's make sure that you are operating your business in a way that conforms to this. You want to control, manage, and monitor discretion and outcomes as best you can. Not that you have to have quotas. That's a question that always comes up. But the sad truth here is that, there needs to be some attention do we need to move more in the direction of quotas, not outright quotas, but do we need to slightly favor some groups or give them a little bit more of a benefit of the doubt than we seem to be, because arguably our statistics show that discretion and outcomes are being managed in a certain way. Look, if you're able to say in a straightforward and clear way, this has everything to do with this particular borrower's creditworthiness or this particular consumer's ability to pay, I don't think we've gotten to the point yet, knock on wood, where the CFPB or other agencies is going to say that that's not a good enough reason. But you do want to make sure that you are monitoring discretion and outcomes perhaps more than your people have been in recent years. And, let's review, revise, and monitor policies. As I said earlier, let's make sure that board and board committee members are involved in hearing about, reviewing, evaluating from time to time what your people are doing in the core areas of your interactions with consumers or the general public. That's all I have for my presentation. I hope it was useful to you. If I can be of any further assistance with these issues, please do call me at my office number, but that's not to suggest that you can't ask me some questions right now. I'm happy to answer any questions that you have, and if not, as I said, I'm happy to consult with you on a private basis. Oh, and there's also a survey that you'll see the URL for on one of the slides here. It doesn't take very long at all to complete. We would ask you, if you don't mind, to take the brief time that's necessary to do that, because again, this is a monthly series. Don't worry, you won't be subjected to me very often at all, but some of my partners are going to be handling other issues in further months, and we would like to get your feedback so that we can make each successive installment in this series conform to your expectations as much as possible and get better and better. So if you don't mind, please complete that. And if there are any questions, again, please let me know. If not, thank you very much.
That does conclude today's conference. Thank you for your participation.